argument in our first case, number 124659, United States versus Graham. Shelton?
Morning. May it please the court. Spanning 221 days, the government collected Mr. Graham's location 30,000 different times, leaving no private haven unviolated.
Can I ask you about exactly what, when you say location each time, that gives the cell tower to which he used a phone or received a phone call? Is that right?
Not
On his cell phone?
of the tower.
The tower, the cell phone tower from which the cell phone he was either using to call or to receive a call pinged.
Not necessarily when he was using the call. There were times the cell tower location identifies where your phone is even when you are not using it.
I thought, though, that in this case that technology had not been developed. In other words, if he's just carrying it along with him. I understood that more recent technology, sort of grows every day, that more recent technology did do that. You just carried it along with you, and it tracked you every minute, your exact location, or at least to the cell tower that was nearest you. But I thought this one was only operated by a phone call or a receipt of a phone call. That's wrong?
No, I believe that's correct, Judge Motz, but that's actually a critically important factor in identifying the privacy interest here.
Yeah, I'm just interested in, if no phone calls coming in or out. This isn't a trick question. I just didn't quite understand.
That is true in this case. Of course, because technology in this area does continue to evolve, it is important that the court take notice of the fact that the intrusion in privacy is getting worse, not better, particularly with the proliferation of cell towers and not just the proliferation of cell towers, but the intensity and narrowness of the range.
But let me make sure I understand. In this case, he only had to be either using the phone to make a call or to receive a call.
Or a text, yes.
Right. So he had to actually be doing something in this case.
No, he did not have to be doing something because by receiving the call or the text, he was not doing anything.
Or receiving a text. Okay.
I think, Your Honors, after Riley, there can be no more question about whether a privacy interest exists. The Supreme Court unanimously described metadata on cell phones, including historical cell site location information, as one of the privacies of life. Unlike Knott's, this is not simply augmented observation. This is retroactively recreating past events that were never observed and were never observable, here averaging one location point every 11 minutes for 7 months. And like the Supreme Court noted in Riley, cell site...
Is it really true that they would not be observable? I mean, somebody could have been trailing him around, hypothetically.
Well, not in this context because the movements had already happened. So in Jones, theoretically, somebody could have been tracking him because it was ongoing prospectively in real time. This case, it was not. It was after the fact the government decided to go back and retrace his steps. So it was not observable. And like the Supreme Court noted in Riley and multiple other courts in the last couple of months, historical cell site location information tracks people into constitutionally protected space, which is
What's your best argument for why the third-party doctrine doesn't apply here?
There are many arguments for why it doesn't apply, Judge Davis. The most critical reason is because the records here are nothing at all like the records that were at issue in Smith and Miller. The level of intrusion of privacy is just categorically different. Smith turned on the fact that it was a very limited amount of information that was conveyed, and that it was the precise information that the user conveyed to the phone company. The Supreme Court in Riley described the pen registers as not a good analog for what cell phone metadata is.
Have you read the dissents in Smith and Riley, and in the two Smith and Miller?
I have, Your Honor.
They make almost the same arguments.
They
that
do.
you're making here. I mean, it's really quite close, and you have to remember that those were back in the days when I was a young woman that these cases were decided. So things that were new then are taken for granted now. I mean, can't you make an argument that the information you got from the pen register was a deeper, wider set of information than the information you get from the ping? You actually know the time, and you know the frequency of the call. You know to whom it's called, to whom you're calling. You know where it's going from. You know it's going from someone's house. And we've always said that the house is a protected area.
Well, Your
So
Honor,
to some extent, you know, if you were up here, you could make the argument that they've already decided your case. It's within that case.
well, except for the fact that that the third-party doctrine didn't stop with Smith. In Ferguson, for example, and in Kwan, where information was absolutely shared with third parties, that was also detailed and extensive, the Supreme Court recognized that the fact that that was conveyed to a third party did not eliminate the privacy interest. In addition, the Third Circuit described how the sharing of location information, if you can call it sharing, because it's not what the user intends to be doing, that it was not meaningfully shared in the way that bank records were in Miller or the dialed phone number was in Smith.
I'm still not exactly sure if you, in answer to my colleague's question, maybe you said there are many reasons, so maybe you can tick off for me the three biggest things that you think may take this case out of the third-party doctrine.
Well, one I just alluded to, which was the Third Circuit's reasoning, which
Well, with all due respect to the Third Circuit, it's a great circuit, but we have to have our eye on the Supreme Court, right?
absolutely.
And we don't have, that's not a Supreme Court case, and so we're looking to fit this in within the structure of the Supreme Court case. And I'm taking up your time, so you go ahead. I'll give the government more time.
Well, it is true that the Third Circuit is not the Supreme Court, but I will also note that Riley did not take on Smith, obviously, but it did take the opportunity, nonetheless, to describe how the information was different and the fact that it was known by the cell phone service provider, potentially by being stored in the cloud, did not eliminate the privacy interest. It also described how even if there is some diminishment in privacy interest because of some level of sharing, that diminishment did not eradicate the privacy interest. I think that Ferguson and Kwan both are important for...
Maybe you can just give me, you don't have to give me case names, just give me the rationale is what I'm trying to search for, the reasons.
The rationale is if the privacy interest is great enough, like personal medical information, or your every move for 7 months, or who you are with, or where you are, if the privacy interest is great enough, then the fact that a third party has some knowledge of it or is the conduit of that information that is somehow used in the scheme of it in the way of
But as I said to you, in the pen register case, there was greater amount of information. You had less privacy out there. So I don't exactly understand what you're saying.
Well, with all due respect, Judge Motz, I don't believe that it is greater information.
Well, there was more particular information about a given individual than the ping on the tower.
I disagree, because nobody knows with the pen register case who is actually using the phone, and it could be anybody in the house. And with a cell phone, you are able to draw the pretty clear inference of who precisely it
You
is.
can give your cell phone to someone else, they can be using it.
Sure, you can.
Well, just so somebody else can use your phone in your house.
And
They
just-
know the phone is in the house in the pen register case. I don't think that's your best distinction.
And just like when you are traveling someplace and you are not actively doing anything but simply receiving a text or
You received phone calls, it was on the pen register. Even if you received phone calls that you didn't pick up, it was on the pen register.
I believe the pen register,
No, you go back and look at the case, I'm pretty sure about that.
fair enough, Your Honor. I will say that the Supreme Court has never required absolute secrecy looking at all of the cases of information that is shared since Smith and Miller, Smith and Miller are as I described
Furthest
it in my
reaches
brief.
out of the third-party doctrine.
I'm
The greatest expression of the third-party doctrine. And I take your point. And so should we just say that they no longer apply in the digital age? Is that
Well-
basically what you would have us do?
I
was trying to write to think, Justice Breyer is always saying, how do we write this?
right.
So since we are in what is generally known as an inferior federal court, as opposed to the Supreme Court, we would try to write it consistent with Supreme Court law.
Of course.
Those cases still exist.
They do still exist.
So that's why I'm trying to get you to give me a rationale to write around them or to distinguish them in some fashion.
Certainly, and the reason would be, although I believe that that Smith and Miller really does need to be reexamined, I understand this court is not the court to do that, but Tracy, the Florida Supreme Court, Augustine, they have not had to reject the third-party doctrine at all to recognize that the level of privacy intrusion and the active conduct by the cell phone user simply don't erase the privacy interest, that the privacy interest is so great and that the cell phone service providers, basically the artifact of technology and the way that the technology is used does not bring it within the same realm as Smith and Miller. In Miller in particular, where the customer was providing deposit slips and checks and the data was the actual data that the customer intended to convey. Here, it was not any degree of intention. I know that I've used up substantially more than my time, Your Honors. If the court is interested in any of my arguments regarding good faith, I would be happy to address those or on rebuttal.
Will you reserve some time for rebuttal? Thank you.
Good morning. May it please the court. There are several issues before this court that are unique to Mr. Jordan. Is it proper for a judge to place a per se limitation on otherwise competent and relevant testimony of a defendant in order to prevent him from implicating his co-defendant? We've argued no. Under Rock v. Arkansas, the defendant has a constitutional right to tell his version of events in his own words. Or in a pre-Roseman case where there's neither evidence nor a jury instruction concerning whether the defendant had advanced knowledge that his co-defendant had a gun, should his aiding and abetting 924C and robbery convictions be vacated? We say yes. Roseman now requires it, even where, unlike here, the defendant was present when the gun was displayed. As to both defendants, whether a lay witness who could never have qualified as an expert may testify about technical matters like how cell phone towers operate and radio frequency energy wave propagation, and then give a lay opinion as to the location of the defendant's phone, we say no, compliance with Rule 702 was required because this is clearly grounded in technology. And we would note that the NIST guidelines on cell phone forensics publication that we cited in our brief was mentioned by the Supreme Court in the Riley case in their discussion of cell phone technology. But I would first like to touch on some assertions that the government has made about the record with which we disagree. This is important because the government relies on these mistaken assertions to support their harmless error arguments. For example, Jordan testified that he was not the getaway driver for the McDonald's robbery, but that rather he got...
Excuse me, Ms. Renee, on the Sixth Amendment question regarding the testimony of your client, what can you point to in the record to show that any error was preserved and not waived?
It was made very clear, first of all, on numerous occasions, months before...
Well, but I'm asking you, if you can, and if you would, to point me to a page in the JA or in the record where Mr. Jordan's counsel said, Your Honor, we understand what you think we should be doing. We object. It's a violation of my client's Sixth Amendment right and Fifth Amendment right, but we'll go ahead and do it the way you tell us to do it. Is that in the record?
Well, to answer your question, Judge, first I would say that if in a specific page in the record on the Appendix 2295, where Jordan's counsel had actually asked the court to advise Jordan of his rights, Jordan's constitutional right to testify before the beginning of the defense case. And the court said, yes, I will. And then on page 2295 said, you have the right to testify. And I'm paraphrasing here.
Well, but see, I'm sorry, you're not responding to the question that I'm trying to get you to focus on.
Well, as I understood.
I think I understand all that went before, but when did counsel stand up and say, Judge, we object to this?
Counsel never said, I object to that.
And in fact, as I understand the record, counsel thought what the judge had ordered was pretty much okay.
That's not my reading of the record, because it was clear to me that
Well, you weren't there, just as I wasn't there.
Well, from reading the record.
Yeah,
from reading
well,
the
we
record,
both read the record, and I'm looking for preservation of error, not waiver.
But in this particular case where it's been made clear to the court on numerous occasions already, my client is going to testify. This is what he's going to say. Then the government
I
objects.
understand all of that. And in a different record, yeah, there may have been a violation, but where is there evidence that this wasn't waived by counsel?
First, by saying my client wants to testify, just
And
like
your
in
client
Midget.
did testify.
But he said he wanted to testify to these specific
Yeah,
things.
but that gets into the weeds. I mean,
But
look,
there was-
do you have a 2255? Is that what this really comes down to? I mean, because your answers haven't been very satisfying.
I don't think so, Judge, because just in the Midget case, where the client made it clear he wanted to testify, and the court knew that the client wanted to testify.
So you want to read defense counsel out of this scenario entirely. In other words, your argument, if I understand it, is that defense counsel cannot waive a defendant's right to testify.
Well, certainly not
And
with...
that therefore, where a judge does what the district court did here, which is to say, well, you know, let's keep it clean and let's not talk about these three things. And when you talk about this other thing, talk about it in this way, not in some other way. You're equating that to a waiver by counsel of the client's right to testify. Is that a fair summary of your position here?
I'm not sure that I agree with that, where the court has been clearly told by counsel.
Keep saying that.
But then
but your client did in fact testify.
And he attempted explicitly to continue to testify to the items that the
And
court
his lawyer
excluded.
acquiesced in the district court's termination of that.
But the right belongs to the client, not
So
to
you
the
are
court.
arguing that the defense lawyer improperly waived his client's right to testify.
It
That's what
wasn't-
you're arguing.
No, sir. I'm saying that this was imposed by the court. And even the court recognized it. And the government even used that type of language in their brief. The court said, I've imposed this upon you. And when the court read the rights litany to Jordan, he said, you have the right to
But
testify.
counsel never objected.
But this is something to which the court would conduct a de novo review, because it implicates a constitutional right of the accused.
So is the
Even-
conflict between the Sixth Amendment right to counsel
This is
and the Sixth Amendment right informed by the Fifth Amendment right to testify in one's own defense? Is that what you're saying?
I'm saying that this is grounded in the Fifth Amendment and Sixth Amendment and the 14th Amendment, as this court has observed. And only the defendant can waive his right to testify, and he was explicit that he was not, and he tried to testify to that. But even assuming that the right was waived, and I don't think that the record supports that, particularly when the judge advises the client.
Well, if you assume the right was waived, that's the end of the argument, isn't it?
Well, because you get into, I don't believe so, when you get into the unfairness of the government's comments in closing, exploiting the absence of those statements, which had been omitted based on the government's request, commenting on that, and then specifically admonishing Jordan to the jury that he should never have taken the stand, and essentially insulted the judicial process by exercising his constitutional right to testify. That was all grounded in the supposed waiver of his right to testify.
Okay,
which
I really
again
didn't
did
want to
not
tie
happen.
up all your time on that one issue, and it happened because I just wasn't grasping your answer. But you've given me your best answer. You're sort of out of time, so I think there may be a couple of other issues you might want to mention with Judge Motz's leave.
Sure.
Well, certainly to keep in mind that this is an entirely circumstantial case. The evidence against Jordan was extremely thin. And with the limitations on his testimony, combined with the inappropriate comments of the prosecutor in closing, which this court in Woods and other cases have said is absolutely inappropriate, especially to accuse him of arrogance for taking the stand, that so infected the entire process with unfairness that his conviction should not stand.
Morning, Your Honors. May it please the Court. Rod Rosenstein for the United States. Your Honors, we submit that this is an important case, but not a complicated case. It is not difficult because the third-party doctrine controls the outcome. It's an important case because the defendants, in essence, are asking the Court to overturn the third-party doctrine. And we submit, Your Honors, that if the Court were to do so, it could not simply be limited to historical cell site information. I believe that the defendants could not argue in good faith that this Court should simply carve out historical cell site information but preserve the third-party doctrine in all other areas. In fact, counsel candidly acknowledged that she thinks the Court ought to revisit both Smith and Miller, which, of course, this Court is not in position to do. I think it's notable, Your Honor, that there were 2 cell phones seized in this case, and one of the important facts, if this Court were to adopt the defendant's line of argument, is that the government, in fact, complied with Riley. Why is that? Well, Your Honors, we obtained search warrants for both cell phones, which were recovered at the scene at the time of the arrest. We didn't search those incident to arrest. We obtained search warrants for those cell phones. But the information at issue in this case was not on the cell phones. Well, why is that? That's because it wasn't the defendant's information. This was Sprint's information. The defendants did not keep track of what cell towers they used. Sprint did. Sprint
Well,
kept...
another way of looking at it is that they didn't dictate into the telephone, their cell phone, what their location was, but only the ping would give you an idea of that. So you're jumping to the argument that the ping information is not theirs, which is sort of the crux of this case, isn't it? That, I mean, I think that the third-party doctrine, both of those cases, the cases that really sort of stand for it to the outer limits, deal with the voluntariness of the disclosure of the person. And isn't all of the rub here whether, in fact, the defendants here were voluntarily disclosing their location to the cell phone ping tower?
Let me address the issue, Your Honor, of voluntariness, but just to preface that, the term ping may or may not have
Probably it's outdated.
technological significance.
Totally outdated, I suppose.
Well, no, but the point I want to make is the defendants, we contend in their briefing, confuse the issue of real-time tracking, which involves the government taking some proactive steps to collect information. That often involves what we sometimes
No,
call pinging.
I do understand that the case law has made a distinction. I'm not actually sure that I think real-time tracking is worse than retroactive tracking, but I do understand that there is a distinction. And
whether
this isn't real-time tracking.
Qualitatively worse or not, the point I was making, Your Honor, is that involves government action. As the government needs to contact the cell phone company or somehow reach out and what we would say is ping the phone to cause it to produce information. But this case...
This requires government action. The government has to ask the cell phone company for the information.
That's exactly right. The only government action here is asking for the records that have already been kept
Right.
independently by Sprint for its own purposes. And we think that's significant. Another issue the defendants and the amicus contend in their brief that somehow the government's responsible for creating this information. There's nothing in the record to support that proposition.
What if the government did have a regulation that required them to gather this information?
If the government required them to create the information when they wouldn't
to
otherwise
gather
have
it
created it.
You'd still have the mechanics, but to do with it what they do.
That would make no difference to our argument, but it would to the defendant's argument, because they seem to be separating the issue of the creation of the record and the maintenance of the record. In other words, our position is, Your Honor, that given that technologically you need to use a cell tower to make a phone call, that the use of that cell tower, just as in Smith, the dialing of those digits discloses that information to the phone provider. Whether they record it or not is not dispositive. In fact, in Smith, as Your Honor pointed out, not only are calls picked up by the pen register that were not completed, but also local calls are picked up. And the Smith opinion acknowledges that at the time, the phone company didn't necessarily record local phone numbers. It recorded long-distance numbers for billing purposes, but it may not have recorded local numbers. But what was dispositive in Smith is that the information was necessarily disclosed. And to return to your question, our position is that voluntariness in this context, when the government is not involved in the creation of the information, voluntariness is simply goes to the question of whether the defendant necessarily disclosed the information in the course of some voluntary activity. For example,
Right, so did they? How did they here?
it's necessary, Your Honor, objectively, in order to use the services of a phone company, you need to connect to a
So
network.
everyone in the country that has a cell phone has no reasonable expectation of privacy. Is that right?
In their
No.
location.
No, our position, Your Honor, is they have no reasonable expectation of privacy in the tower that this phone company uses to complete the call. That's a little bit different than saying in their location, and the relevance of that.
How is
Your
that
Honor,
different?
It's different in this sense. A cell phone is capable of computing your actual location. In fact, most modern cell phones will do that. They use what's called GPS, geolocation. They can tell you precisely the longitude and latitude where you're located. You may want that for your own purposes. You may disclose that information to third parties. But that information is not what's at issue in this case. In this case, what's at issue is the connection to a cell tower. And our position, Your Honor, is that just as in Smith,
But every cell tower has a location, Mr.
of the
Rosen.
cell tower, that's correct.
Yes, and every cell tower has a limited range.
That's exactly right.
So I'm not sure I get the idea. I understand the argument, but it's a matter of miles versus meters versus kilometers versus precision.
But it's a matter
That's
of,
why the government wanted this, to put them in particular locations at the time of the various crimes.
as was pointed out earlier, Your Honor, it puts the cell phone in a location, you add that to other corroborating information to prove the defendant was in that location. It's one piece of evidence. But, Your Honor, it's really no different than any piece of information. If there's a robbery, we often will collect surveillance video. The defendants didn't know there was a surveillance camera. That surveillance video would show you they were in that particular location. The purpose of the video wasn't to locate the defendant. It was for the store to keep track of activities for its purposes. But the defendant, by putting himself in a position where he engaged in a transaction, and our position, Your Honor, is that this is really no different than the use of a credit card or ordering from Amazon.com or anything else. You're
What if the
asking,
cell phone is given to the defendant as a gift? In other words, the voluntariness necessary here is just turning it on and having it on your person or in your vehicle.
no, Your Honor,
Well, what's the voluntariness other than just turning it on and having it on your person?
in this case, the voluntariness is asking the phone company to connect a phone call for you. You know, you need to have, you can use a smartphone without a connection to a network. You can turn it off in airplane mode and just use it as a
So a
computer.
person who gets a cell phone as a gift, my stepdaughter's cell phone, she's voluntarily, in other words, that's all it takes. In your submission, you turn it on, you have voluntarily submitted to the provider's decision to keep track of your movements, even for unanswered phone calls.
You voluntarily,
So you literally never have to use the phone.
well, remember, Your Honor, the issue in this case has to do with completed phone calls. It's not tracking outside of not completed, but phone calls, incoming and outgoing.
Exactly. So you don't have to answer the phone for this to be implicated.
But, Your Honor, for the court to rule otherwise would necessarily require you to find that the phone company is committing some sort of tort with the phone user.
Well, just a minute. In the pen register case and the bank case, they talked about them being business records, and I assume you would say that this CSI, CSL, or whatever it is, material is also a business record,
It's a
right?
business record of Sprint, it's not the defendant's
Right,
information.
but Sprint doesn't, what the user gives to Sprint is less than what the Sprint then does with it and then gives to the government. Whereas that's not the case with the telephone or the bank records. I mean, in other words, a different item is coming out than the person put in. Yes, because if you just gave them, this person uses the cell phone and there is the ping there without any location. If you didn't tell them the location thing, which you wouldn't have to do that.
Well, Your Honor, if you're driving your car down the highway and you pass a camera that takes a picture of your license plate, that information is now on the camera. The license plate is now on the camera. The person who goes through a toll booth, for example, to pay a toll with an Easy Pass, a record is kept of the fact that they used the toll booth. It's really not any different in the sense that, Your Honor, that when you turn on your phone and you request service, you have to sign up for service. You need to sign a contract.
What is
with
But
service.
you have your cell phone in your home sometimes, not out on a public highway. It's in your home.
Just like a
And
regular
that-
phone.
Right.
Just like a regular phone. I mean, you know, if you want to use it, you need to plug it in. Now, although a wireless phone connects wirelessly, it's no less of a physical connection. I mean, Sprint needs to have a tower to complete that call. You can't make a call unless there's a tower and you've connected to that tower and you have bars on your phone indicating that there's a connection. So in order to complete the call, you can use the smartphone all you like in airplane mode. If you want to take advantage of the wireless connection, you need a provider. You need a cell tower to complete that connection. And that's the voluntariness in the context in which it's a third party collecting the information. As I say, there's no allegation here that Sprint violated the defendant's rights by keeping a record of what cell tower the defendants were using.
What was the import from the government's position of Congress saying you can get an order or you can get a warrant? What's that all about? Is that just stupid?
Absolutely not.
Okay, what is the rationale behind that?
We can only speculate as to what the rationale is, Your Honor.
Okay.
And I wouldn't want to speculate about what was in Congress's mind, but I think that if you look at the statute, the purpose of the statute was to create some statutory protection for information that Congress recognized had no constitutional protection. And we think that that's the appropriate way to deal with emerging technology.
When has the government sought a warrant in lieu of an order? Why would any prosecutor in his or her right mind go through the additional hoops of a warrant, not that that's all that onerous, if Congress has said you can get a court order?
If you're looking only for non-content information,
Well, but isn't that covered by Title III?
well, Your Honor, there's some ambiguity about the content, for example, of emails. And I believe in most cases we are using warrants to get content of emails. That is, what's inside the envelope.
I see.
To use a physical analogy. But the
So is that DOJ policy as of the time of this order or today? That
I don't know that there's a written policy, Your Honor. I know it's been our practice that to obtain content information, we're using warrants. And of course, in the wake of the 11th Circuit's decision, before it was vacated, I think many offices were in fact using warrants just as a protection against
I
that.
think that's one of the weakest parts of your case. It's hard to understand why you didn't get a warrant here. You had them in custody. You knew they were bad guys. You had it seems to me, all kinds of stuff that you could put in a warrant.
Keep in mind, Your Honor, as I said, we did get a warrant for the cell phone.
I understand that. You
But-
made
but-
that very clear.
But
I've
keep
got
in
that.
mind, in the course of criminal investigations, what investigators do is they go out and collect information from third parties, and they don't get warrants to get information from third parties. Third parties.
Well, you went and got this order. You went and got something, so why not get the warrant? You know?
Well, one reason, Your Honor, is that the judges don't want us taking their time getting warrants when they're not required by law.
But would it have
Can't you get
taken
this from
more
a magistrate
time?
judge?
Pardon me?
Can't you get this from a magistrate
You
judge?
can, but
But didn't the magistrate judge give you the other thing that you got under the
yes,
statute?
but a warrant is a more
Well,
time-consuming
but I mean,
procedure.
you're taking up their time. You think it's taking up a lot more time to get the warrant than
I got a call from a magistrate judge last week in a case where we had submitted a warrant application asking why we did that. Why couldn't we just obtain an order? So,
And you said because there's this Graham case up before the
right?
Fourth Circuit.
There might be.
no, he actually said now that Davis has been vacated, why would you have a need to do this? But anyway, as I say, I can't answer the question as to why Congress provided those two options. I know that our position is that when we're seeking information that's clearly third-party information, non-content. When I say non-content, what I mean is the location of the cell tower is something Sprint needed to know to complete the transaction, Your Honor. And the analogy we use is UPS or Amazon or Federal Express. They need to know where you're located to deliver your package. They need to know where your phone is. My phone is in Richmond today. Yesterday it was in Maryland. How does the phone company know to send me a call to make my phone ring in Richmond? Only because my phone notifies the cell tower I'm in the neighborhood.
So does this mean for every 7-Eleven robbery, every McDonald's robbery, every gas station robbery in America, the United States attorney could theoretically go to a magistrate judge and say, we want all the cell site location data for every phone within a 2-hour period of the robbery. And you probably already have algorithms in place that in about 2 minutes could identify, the 19 phones that were talking to each other within a mile and a half of the robbery location during the robbery. I mean, that's not far-fetched, is it? It may sound far-fetched.
If we can meet the criteria of the statute,
Yeah.
then...
Well, there was a robbery. What more do you need to know? If your argument just now was this was just investigative activity, looking at pieces of information.
That's right.
What? I mean,
The basis for the order here was that the defendants were suspected of being involved in armed robberies.
right.
And your hypothetical is the same thing. And I would say yes, and thank God we can, because there are cases where it's really necessary to do that. You have a kidnapping. We had one recently, a kidnapping in which we were able to identify the location of the victim and the perpetrator in part based upon cell phone tracking
And
information.
that sounds like exigent circumstances from here till Sunday.
Yes,
Here, you had guys in custody, what appeared to be a fairly substantial circumstantial case. And indeed, you argue harmless error here.
but the issue, again, Your Honor,
I
I'm
mean,
not
you're
arguing.
arguing you really didn't even need this cell site location for this conviction.
I'm not arguing that we couldn't obtain a warrant. My point is simply that if you were to make an exception of the third-party doctrine, there'd be no reason to limit it to this case. And what else would it extend to? The defendants want to extend it to wipe out Miller and Smith as well. In that
Well,
case,
let's look at it the other way. Is there any thing to which the third-party doctrine doesn't apply? What if you had in just like next year, the cell phone company able to track and collect all real-time location so that they were aware of your exact location at every single moment? Is there any, does the third-party doctrine extend to that?
and Your Honor, my answer to that is that the Fourth Amendment cases are extraordinarily fact-bound,
Indeed.
and we don't think the court should be speculating about
But you were
emerging
just
technology.
telling we when we're making it the law, we're making it for the future as well as for the case in front of us, and so we have to have an eye to that, and the Supreme Court clearly does too. So, are you suggesting that there's no boundary to the third-party doctrine?
Your Honor, what I'm suggesting is that to the extent that there is a boundary, this information doesn't come close to it. That this is
Well, what about the hypothetical that I posed?
emerging technology. Your Honor, I think your hypothetical, to some extent, it's reality. I mean, many people permit third-party vendors to track their location. You can click that option on your phone, and when you walk into Target, Target knows that you're there.
That is an option, though,
that is
that
an
you
option.
click on your phone, unlike this. I mean, nobody's clicking on their phone to be tracked.
But you've
because
asked me about the hypothetical. The hypothetical, I mean, if you're making a voluntary decision to turn over that information for commercial purposes to a third-party provider, then my answer would be yes, we can obtain that in the same way. And that's why, why do we obtain a court order in this case? Well, Your Honor, in most cases that are not protected by the Stored Communications Act, we don't go to the judge at all. We just issue a subpoena for the information. And where would the defendants draw that line? You look at Miller, for example. Think about all the commercial activity that becomes relevant in criminal investigations, where you want to go out and subpoena somebody who may have sold a weapon to a suspect. We would have to go to a judge if there were a requirement that in order to get third-party records, you need a court order. So what I think is important to recognize here is we're talking about a situation where, because of the Stored Communication Act, we actually have an elevated requirement to involve judges in investigations, where the baseline actually is that investigations occur, third parties are questioned, and information is obtained without any judicial involvement whatsoever.
So what was it that the defendants did here to voluntarily provide information that the government could access through the third-party doctrine? What did they do?
What the defendants did here is they voluntarily
Had a phone?
voluntarily placed calls using Sprint's wireless network. Just like in Smith, they voluntarily placed calls using the phone in their home. And the third party created the record. But again, our position, Your Honor, is that when the government's not involved in the creation of the record, voluntariness is really not at issue in the Fourth Amendment analysis. I don't think you'll find that in the cases where The record was created by a third party acting independently of the government. And the government's only role is to come in after the fact. And the record, I believe, is quite clear. The defendants have talked about governmental involvement, but the factual record is clear, and the district court found, and a Sprint witness, I believe, testified that this information is kept by Sprint for its own purposes.
But you'd need a warrant to open up somebody's letter.
That's exactly right. To
I
get
mean,
the
they give it to the Postal Service or to FedEx.
Well, Your Honor, we would, but actually FedEx doesn't. I mean, FedEx is able to open envelopes if they think that there's something suspicious inside. They may open it and turn it over to the government. The defendant wouldn't have consented to that, but the third party did it. And that's my point. The third party doctrine is a bright line, where if the action taken by the third party was not done at the order of the government, then the defendant has no expectation of privacy. That's an action taken without any government involvement at all. So I think that's a useful analogy, where what we're talking about here is simply the addressing information on the envelope. Where did FedEx pick it up? Where did FedEx deliver it? We're not interested in what was inside the envelope. Thank you very much.
Judge Motz, I wish I had thought of this my first go-round, but I would like to say that Caro and Kylo both were decided by the Supreme Court after Smith, of course, and those discussed tracking via electronic means into a private space and found that the fact that there was tracking outside did not matter. The third-party doctrine was still not enough to eliminate the privacy interest. And of course, Ferguson and Kwan and so forth, and Reporters Committee to talk about how when the information is not intended for public consumption, it still remains private, even if the government has access to it from some other records. The scope of this information is really important. Smith involved 13 days. This involved 7 months. It's daily, all-encompassing information. It is not a situation where FedEx or ordering something on Amazon is remotely analogous. Those are Miller. Those are the situations where the user conveys specific information, intending that company to use that information to provide the specific service.
Ms. Skelton, there were 2 orders.
Yes,
The first was fairly narrow. You agree?
I do.
The second, much broader.
Yes.
Scope of information. Did the government use information from the second order? at trial?
Absolutely it did.
Can you give us some measure of how much information the government used was derived from the first order as opposed to the second?
I'm sorry, Judge Davis,
Okay.
I can't be that specific. But what I would say is that given the breadth of that order, it was not...
That order being which one?
The second one.
All right.
Honestly,
But didn't the witness testify that he didn't look, he had a more, this doesn't take anything away from the breadth of the information that was gotten, but I thought the government witness testified that they only used very specific portions of that second great big sweep. Don't
I'm
remember.
afraid I don't remember, Your
Okay.
Honor. I would say that the fact that it was so broad, and the first one was broad enough to...
Well, in customary Fourth Amendment analysis, when a warrant is too broad and things are seized, mostly what we do, I think you agree, is we say, well, let's look at the warrant and see what's clearly covered, and that doesn't get excluded. You only exclude what's beyond the boundary of what would have been a particular warrant.
Well-
Does that principle apply here?
These were general warrants. These were exactly what, the Dragnet general warrants, and I do not believe that the government could have gotten a warrant for any of this information because the actual applications that they submitted said essentially the defendants were arrested and had cell phones, and we have some unsolved robberies, which are like to know if they were nearby. They had nothing particularized about the defendants. So I don't believe they could have gotten a warrant based on what they submitted. Maybe they could have crafted an application for a warrant that did include more particularized information, but what they submitted here was not the equivalent.
Okay. Can we talk for a minute about good faith?
Sure,
Because that's the elephant in the room, isn't it?
it's an elephant. There are at least
You
three
think there's
reasons.
more than one in this case?
There's a couple. There are at least three reasons why good faith does not excuse this warrantless search. The first is what you have already alluded to, Judge Davis, that the statute is internally contradictory. So it does not, unlike Krull, where it was a very limited statute,
Well, I'm not sure it's correct to say it's contradictory, not to pick on words, but Congress said you can use this procedure and you can use this procedure, and the government chose the arguably less onerous procedure. That doesn't contradict,
well,
does it?
fair enough, but what it does not do is it does not limit law enforcement discretion. And generally, in order to rely on a statute in good faith, the statute itself must say, this is when you can search, this is what you can search for. It does not convey broad prosecutorial discretion in what they could decide.
Okay, I know you've got two other reasons, but I don't think the government's arguing here specific, the government is not tying itself to Krull and the statutory authorization argument. I think it's more of a totality of the circumstances, sort of a more traditional good faith analysis, one factor of which is, after all, Congress said we could do this. So I don't think you see what I'm saying. So we've got that, but the government's got other reasons why good faith should apply here as well.
So looking at the totality of the circumstances, again, the scope of the search, 7 months, the 30,000 location points, that's one of the circumstances. Another is that it was a lawyer, a prosecutor, one of the advocates in the prosecution who was the person seeking the order. It was not simply a police officer making a split-second decision.
That kind of hurts you, doesn't it?
I don't think it does. I think that what
Supreme
that...
Court's never told us that we're supposed to be deterring prosecutors.
Well, the Supreme Court...
Maybe they should.
The Supreme Court is saying that what it has to deter is future Fourth Amendment violations.
By police officers, by law enforcement.
By law enforcement, and I think that assistant U.S. attorneys are part of the law enforcement community, if you will.
If judges can make mistakes, why not prosecutors?
Because the Supreme Court has specifically said that magistrate judges are not likely to be deterred because they are not parties to the action. They don't have a stake in the prosecution. Prosecutors, like police officers, have a stake in the prosecution. And Herring talks about the whole point of good faith being trying to deter future violations,
By law enforcement officers.
which should include other advocates in this.
But you agree there's no Supreme Court support for the notion that good faith doctrine is intended to defer prosecutors.
The people who the Supreme Court has talked about as being not subject to deterrence are clerks in the clerk's office and magistrate judges. Those are the only specific people that the Supreme Court has talked
That's a
about.
fair response.
But what they have talked about is if there is a close call and somebody is either acting recklessly or grossly negligently and is making a choice that violates the Fourth Amendment and suppression could change that choice, then the deterrent the deterrent purpose of suppression is served, and that is what would happen.
So now that argument does bring you into the teeth of the statute, because you're asking us to deter Congress.
No, I'm not asking you to deter Congress, because Congress said get a warrant. Congress
Well,
also
Congress
has,
said, get a warrant,
Or-
get an order.
Get an order.
and courts, since Congress said that, courts had gone all over the place. You can tick off a scorecard of courts that had said you have to get a warrant, or no, you can get an
But sort
order.
of, how does that help your argument?
That helps because that's where the fact that it is a litigant and a lawyer comes into play.
Okay.
Because at that point, that's somebody who should be charged with knowing about the constitutional debate and at least the fact that the statute is not the most constitutionally sound statute out there. Thank you.
Thank you very much. Ms. Burnett?
As Judge Mott says, the cases are being decided not just for today, but for the future. And I'm thinking back to my own very happy days as an overworked federal law clerk. And I remember how helpful it was when I knew in advance whether or not a defendant was going to testify. In this particular case, it's ironic because if the attorney for Mr. Jordan had not cooperated with the court's requests on several occasions to tell him whether or not Jordan was going to testify, and simply saying, I don't know, Your Honor, and play that kind of game that the government is advocating, his client would not be in this position. He would have just taken the stand, testified to what he wanted, and then, according to the government, created a mistrial. I don't think that's the type
Well, they
of...
had a potential Bruton problem, so if he had to disclose it.
The defendant had to disclose that he was going to testify?
At some point before testifying, I mean, before he goes on the stand, the court has to figure out the Bruton issues,
But-
right?
but
The
there-
two of them
well,
are
they
tried
may-
together.
It was clear that there wasn't going to be any Bruton issue, but he didn't have to be specific exactly as to
Well,
what he was
okay.
going to say on the stand. And in this particular case, though, I would also point to the fact that in the Midget case, where not only did the defense counsel not object, but he was the advocate for the defendant not taking the stand. And the court's decision was grounded in the fact that it was the defendant who said, well, I do want to take the stand, but I can't. And in this particular case, Jordan is on the stand saying, I want to say these things, and I explicitly said, there are things here that I cannot say. So when it comes down to addressing the waiver issue, I really think it's important to look at the practical realities of what happened in this case and what's going to happen in future cases, depending on what type of a message that's sent. Furthermore, I'm not sure that we're looking at the order of how all this transpired correctly. Somebody asserts that they're going to introduce particular evidence at trial. I'm going to testify at trial, says the defendant through his attorney. Objection, says co-counsel. Objection, says the prosecutor. Granted, says the court. That doesn't mean that the defendant never raised the issue. He raised it on multiple occasions. It was raised in the Midget case. Now, if we look back at the...
I think that Judge Davis's questions were going to was whether it was preserved, because I personally read the record as the arrangement with the government and that the government had agreed to and that the district court had said originally was different than the conditions under which he was required to testify. But the question is whether he preserved whatever the original understanding was or not. And
Well-
that's what we look at the record and try to figure out. And that, to the
understand.
extent you can, maybe you don't think that's valid, but if
Well,
you do, maybe you can address that.
Well, in the Midget case, for example, it was the defendant himself who preserved the issue. And certainly in this case, the defendant himself was just as clear that he wanted to testify, not just generally, but to those specific items. And if the court would like, I can file a supplemental letter indicating
I think
exactly
we've had
what...
more than enough supplemental 28Js in this case.
No more.
Thank you very much.
28J.
I do want to take, it with Judge Motz's indulgence, 30 seconds. Here's a scenario that you seem not to have contemplated, but perhaps you have. You probably have. As we all know, no lawyer can knowingly put on perjured testimony. And yet, constitutionally and ethically, a lawyer must advocate for her client's rights, et cetera, vigorously, and so on. So client says to the lawyer, this is what I'm going to say. Creates problems for the co-defendant. Government is concerned, doesn't want to try the case twice. Court's already denied a severance. And the court says, okay, to protect the rights of the co-defendant while at the same time permitting the defendant who wants to testify, here are the things he can't say. Now, defense lawyer is standing there and knows that he or she has to say, Your Honor, I object, and thereby preserve the record, or acquiesces because what the judge has proposed elides a looming ethical conundrum for defense counsel. You don't think that's very...
Well, I don't think that's what happened here because...
You don't think that's what happened here?
I don't think that's what happened here, and the reason I say that is because defense counsel in that case said on a number of occasions, I'm not trying to be obstructionist, Judge, So clearly what he was trying to do was not stand in the way of the court moving forward. There's absolutely no indication that he had any reason to believe that this wasn't true.
And the evidence with respect to your client is pretty thin.
It's extremely thin. It's a purely circumstantial case. And particularly when we look at the ruling in Rosemond, where you have to establish intent and advance knowledge, his inability to talk about these things, which were central to exactly what he was, the core of his defense. Yeah, I think it was error that the government simply can't overcome, especially in view of the way they exploited those absences during their closing arguments. Thank you.
Thank you very much. And we particularly thank you, Ms. Burnett, because I understand that you're court appointed. We very much appreciate your efforts. We couldn't do this without you. We will come down and greet the lawyers, then go to the next case.